I'm going to just touch on a few things. You all got, I think most of you got the two notices that we sent out. We sent out a notice in January with some bad news. And we sent out a notice just recently with the good news. Good news. The point is, you know, there hasn't been a lot of changes in the Medicaid law going. The last major change was in 2006. So some of you who were before then, you know, again, I'm going to be hanging around. You can ask me individual questions. We have the room till 3 o'clock, so there's no problem with coming up to me and asking me any personal questions you want. But I just want to touch on the recent things that happened. Last year, the governor, our new governor, Governor Cuomo, who I voted for, decided to have his Medicaid redesign team come up with a way to raise more money. And what they came up with was this idea that they were going to expand the state recovery. Medicaid, as you know, I always tell people, you know, Medicaid is somewhat sneaky. There are certain things that are exempt, like your home, like IRAs, things like that. But what they don't tell you is it's perfectly fine, it's safe while you're alive, you know. But then on your death, if there's something that you've left in your name, like your house, they look to attach a lien to get back everything that they've paid out. And so one of the things that we've done as elder law attorneys is the planning, is we look to transfer those exempt assets in some way. Your home, we transfer with the person keeps a life estate. We've done that for a lot of you. Well, we transfer the home into an irrevocable trust. Okay, and you also have joint accounts. You have accounts that name beneficiaries like the IRA. The way it always worked in New York is that anything that passed through your will, or if you didn't have a will, that passed by law to people through the court, was subject to the Medicaid lien. But if something passed automatically, if you had a beneficiary, or if it's a life estate where it died with you, okay, or you know, anything of that kind where it passed, regardless of what your will said, or without the will, it passed automatically, you didn't have to go through court, nothing like that. In those situations, Medicaid did not have the right to attach a lien to those benefits. So if we, for example, if we transferred your home and you kept a life estate, that property was safe. On your death, your life estate, your right to live there for the rest of your life, died with you, and there was no problem. Medicaid couldn't get their little paws on it, all right? What the Medicaid redesign team came up with, and which went into effect for a while, is that Medicaid could now attach a lien to non-probate assets, to assets that passed, even those assets that passed automatically. So if you had a joint account or a bank account that named a child as beneficiary, that before would pass automatically and would not be subject to the Medicaid lien, now it would be. If you had a life estate that died with you and would not be subject to a lien, now Medicaid had a right to value the life estate the moment before you died and attach a lien to that. Okay, if you had an IRA that named beneficiaries, it was an exempt asset, the IRA. On your death, it would go to the beneficiaries. Now Medicaid could attach a lien to the IRA that before the beneficiaries got their got inherited the money. So that created a huge problem for us. Anybody with a life estate, we got, many of you know, we got a number of frantic calls from people that we did life estates for. And we had to think, you know, is this a situation where we need to change it? And for the most part, you know, we took a wait and see approach, and it worked out good because our legislature, thankfully in New York, with a lot of pressure from the New York State elder law community, came to realize that this redesign that the governor proposed wasn't going to generate much money for the state. Really just a fraction, a couple of $1 million, and was a very harsh thing. There was also a question of whether it was going to be retroactive. If you did a life estate in 2000, and the law went into effect in 2011, was it going to affect you? We didn't know. The way the law was written wasn't very clear, and it seemed like there was a good chance it was going to affect even those retroactive problems. but the legislature repealed it all. And so that was the good news, that we're back to the way we were, that no longer can Medicaid attach anything to anything but an asset in your name alone at the time of your death. So if you have a life estate, it's okay. If you have a trust naming beneficiaries, that was never a problem, but people were frightened. It's okay. If you have an IRA with beneficiaries, it's an exempt asset. If you're on Medicaid, it's okay. It will go directly to the beneficiaries. It will bypass Medicaid. A joint account or an account in trust for, all those things are once again safe for Medicaid purposes. And people ask me, well, what's going to happen next year? Is it going to be a problem again? Personally, now I'm a terrible prognosticator, but I don't think so. I think, you know, the state realized that it wasn't a very effective plan. It wasn't going to raise much money, and you know, it was very unpopular. And so I think we're okay for the time being and for the foreseeable future. So for anybody who is worried about that, you know, we're safe. We don't have to change life estates if you have it. We don't have to, you know, redo any of the things that we've done in the past. It's always a good idea. I say, you know, if you want, you all know you can, you know, Lou and I are pretty good at answering the phone. If you have particular questions about your particular situation, you'll call. We're both going to be here wandering around all day today for you to call. But I wanted to touch on that. Any questions about this, about the change in law? Does anybody have any general questions? Again, particular questions about your situation, I'll be glad to deal with you on a personal level. I wish they turned the Yankees. I'm trying to have lunch here. Yes, sir.
That's just Medicaid, it's not Medicare.
Medicaid. This is just about Medicaid. Medicare is not a financial test. Medicare is based on the fact that you paid into the system and you're either 65 or disabled. So now the problem with Medicare is that it doesn't cover long-range illnesses. It covers short-term. You know, Medicare, when it was passed in 1965 for people over 65 years old, well, in 1965, over 65 wasn't that much, and you probably weren't going to live that long. Thankfully, things have changed as I get close to 65. You know, so I'm pretty happy about it.
But I just wanted a suitcase. I can't have money until they take their money out.
Well, Medicare will have against lawsuits. Yeah, right. You know, and that's something where you're and Russell Morrow, who I'm going to introduce after you have your pasta, who's going to talk, is the negligence guy. He's my associate. He's right across the street from our office, and he's going to talk about that. So you know, Medicare, there are liens, and that's when you have lawsuits, and that's what your you know, your negligence lawyer should deal with. But what we're talking about is when we're doing Medicaid planning, and you're getting benefits on the long term, and then after you die, you find out, you won't find out, you won't care, but your children will find out that there was an extra child you never told them about, the Nassau County or Suffolk County or New York City Department of Social Services. And they come in and say, oh, well, wait a minute, guys, you know, we laid out $381,000.92, you know, and we want a lien attached to this property, to whatever is still in that person's name on their death to get back what we paid. And that's part of what the planning process for Medicaid, that's a big part of what we do to protect that money. And that's what was in jeopardy for about a year, but no longer. Okay. Mr. Sheck.
What's the record of recovery by Nassau County?
Nassau County, the record of recovery for Nassau County is very good, unfortunately. Nassau County is very efficient. Sometimes, not so much, you know, but sometimes in the past, New York City would forget, would overlook. You know, you might get away with it in New York City, but not in Nassau County. They're right on top of it. So that if there's money owing, and if there's assets in that person's name, or the spouse, you have to be careful. Medicaid looks at it like, you know, and there's an argument, you know, we have a difference of opinion. A lot of us think that they can't do it, but they think they can. They come after the spouse, and they do. And many of you here are aware of the fact of what happens when they think they can do something. and then we fight it out for months and years. So Medicaid will look to attach a lien to assets in the name of the person who was on Medicaid after the death, or the name of the spouse after their death. So spouse has to be careful too, that to make sure their assets are going to pass automatically. Somebody got a home run for the other team. Yeah. Oh, Texas. Oh, no. I'm getting like my wife. She sees the replays and she thinks it's something else now.
You're the only one that can see
Another
that.
goal.
Yeah, there's something different on this team.
Okay. The Mets are playing this afternoon. Why aren't the Mets on? No, nobody wants to see the Mets. Yes. Yes.
John, I understood a while back that it was more difficult to get Medicaid for in-home care than for nursing home. Is that still the case?
No, actually, it's easier to get home care Medicaid. The beauty of home care Medicaid is that there are no transfer penalties. And, again, some of us know it's not that easy. but theoretically, it's easier because there are no penalties when you transfer assets, when you make gifts. So, I joke, if you make a transfer during the 5 years prior to entrance into a nursing home, there's a period of ineligibility. But if you're making a transfer for and applying for community Medicaid, which is anything but the nursing home, even the hospital, but typically home health care, home health aid, there are no transfer penalties. So you've all heard my joke probably, it's like what's the best answer to what have I given away in the last 60 months if you're applying for community Medicaid, and it is, yesterday I gave my beloved attorney, John M. Bigler, $1 million, which I'm waiting, not one of you has ever done that. I'm still waiting, but the idea is, you can give all your money away to anybody you wish. You can give $1 million away without paying gift taxes, and there are no penalties for community Medicaid. So in fact, it's theoretically easier to be eligible for community Medicaid than for institutional Medicaid. You just have to get down to $14,250.
And they're talking about recovery. Does that cover community?
Yes. Recovery, Medicaid will look to attach a lien for benefits paid out either in community Medicaid or institutional Medicaid. So it's important for applicant and spouse to make sure that their assets will pass automatically on death. A lot of times people come in, I tell you, the older you are, the less important your will becomes. And so someone who's 85 and not in great health and calls me and says, I want a will, I'll usually try and talk to them about it first and say, that might not be the best plan. It might be more important for you to think about protecting the assets, because anything that goes, first of all, if you have a will, you're not moving the assets out of your name, so they'll be available right off the bat for Medicaid purposes. On your death, whatever is in your name, what passes through your will is going to be subject to a Medicaid lien. Right.
John, you did say that a checking account is protected, a joint checking account after tax?
If it joint with a child, if it joint with the spouse, it's,
No, joint with an adult child.
Now, it was for a year we were concerned, and we're not anymore. Yeah. Yes, it's definitely good news, which we've had a problem with. We don't always get good news.
Will Nassau County go after the children?
Good question. Will Nassau County, or will any Department of Social Services go after children? Children are not legally responsible for parents, okay? And so no, they can't. Now, I should qualify that by saying, now, if there was a gift to a child during that 5-year period, what can happen, and the person goes into a nursing home and is applying for Medicaid and gets denied because they made this transfer to children during the period of it, that 5-year look back. The nursing home may sue the children for that money that was incorrectly gifted. But once Medicaid is established, only for that money, and once Medicaid is established, Medicaid themselves do not have the right to go after children.
What about the opposite? Can me as a mother of a disabled child, if he needed, extra help with the Medicaid, would they go after me?
No, an adult child, right? Yeah, no, that's not a problem. Again, you're responsible for minor children and for spouses. you're legally responsible for spouses, which is sometimes why people, when they see a problem coming down the road, like someone's, your spouse has MS, and you're worried, people have in the past have done a divorce, a political divorce, and they're looking at me, they want to serve the pastor. Any other, but I'm going to introduce, after your next course, my associate Russell Morrow, who's a very smart negligence attorney. And the beauty of Mr. Morrow is that unlike some who are in a big hurry to settle the case and get their fee, I remember in the past having guys say, well, I've got to pay my overhead this month. He's not like that, so rather than a quick, 50,000 settlement, I'm not gonna, blow things up, but he might get you a lot more money because he's patient, he's honest, he's fair, and like us, he returns his phone calls. But I think you're gonna talk, I think they're gonna serve, let's find out.
Yeah.
I think they're gonna serve the pastor, and then Mr. Morrow will talk to you and answer any of your questions. Yeah, it's important, he's good that way. Ms. Burns?
You have an account that the TOD, transfer on debt.
Yeah, that's okay. That passes automatically. Again, you can have that account in your will say, I leave it to John Bigler. I'm not getting it because it's automatically passing to that person that you named to transfer on debt. And so that's not subject to a Medicaid.
Oh, it's not subject?
No.
Oh, transfer on debt is not?
No, that's the same as naming a beneficiary. That's fine. Okay. All right, enjoy your next course. Mr. Lamberson, you're going to get food, I promise. Excuse me. I swear.